Welcome back to News Centre. Now, Electronics and IT Minister Ashwini Vaishnaw has said that the industry will have 2 years' time to comply with the Digital Data Protection Act and the rules. Now, speaking to me earlier over the weekend, the minister also said that India does not need data protection laws similar to Europe, which he says are stifling competition and innovation.
When this law was presented to the Parliament in November 2023, we had very clearly promised that it will be digital implementation. Sure. It will be completely digital by design. So in the last 1 year or so, despite the elections being there, general elections being there, we have worked very meticulously to create a completely digital portal, digital workflow, digital processes, so that when we finally start implementing this law, the entire data protection board will be fully digital by design first. Second, as you are aware, this is a very pragmatic approach towards data protection, and we have made sure that the balance between innovation and regulation, we have a huge innovation economy, right? Huge, large innovation startup ecosystem. And we have to make sure that citizens' rights are protected with full fervor, full confidence. So that's why we have created this structure where the innovation and regulation is properly balanced.
Okay. Let me ask a follow-up question then. When we talk about, you talk about balancing the rights as well as the obligations. You talked about a completely digital framework. I was going through the rules. Interesting bit that I think DPB will be the first board which will operate virtually, with the chairperson and the members connecting virtually as well. So let's take this next logical question in terms of what does this do as far as obligations of data fiduciaries or companies collecting data is concerned? What does it mean for them? What are the obligations they're now looking at?
The obligations on the data fiduciaries are very well established as per the principles set out in the Honorable Supreme Court's judgment regarding consent, regarding purpose. All those obligations are properly set in the law, and the rules basically implement those. Like the law, the rules are also very simple in language. Very clear examples, illustrations are given everywhere. We have made sure that, as I said, in a very pragmatic way, we have made sure that we have not made everything very prescriptive. We have kept, because digital technology doesn't stand, right? It evolves every week. Every week there is a new thing which happens. So the law should be able to catch up with those developments. So that's why we have set the principles in the law and the rules, and the actual practice, the actual prescriptive, which whether to go to left, go to right, or how many steps to take, all that thing is part of the execution, and that's a very good framework which we have set. And we believe, we understand from whatever we have heard from our international counterparts and all, the compliance burden which happened in Europe and which killed the entire innovation ecosystem, which kind of damaged the innovation ecosystem in a very big way, that will not happen. Our innovation ecosystem will continue to grow with a proper legal framework.
Which is the next question that I had in mind. You make a reference to the compliance burden. We're looking at a situation where a company is required to have a data protection officer. There are requirements in terms of security requirements, reasonable security requirements that they're required to deploy, requirements with respect to storage and then processing of data. What does this do in terms of compliance, especially for some of the smaller entities that startups, innovation ecosystem that are collecting data?
Most of these things are today standard practice in the industry. For example, all the compliances, all the obligations that we have set, our interaction with the industry clearly indicates that people are fully prepared for implementing this. And we have given enough time, and we have interacted very closely with the industry in a very collaborative manner, so that there shouldn't be any disruption because of this law, right? So we have made sure that people are prepared, they come up to this level, and despite that we'll be giving a very reasonable time frame for people to give the final compliance.
One additional question, sir, one new aspect that we've seen has been from the perspective of data localization. There is now a provision in the rules which allows for the government to prescribe what kinds of data can travel overseas and which are required to be.
So there is no difference between the Act and the rules.
Sure.
The Act itself in the section 16 very clearly said that wherever required, see, we studied the best practices in the world, and we said wherever data is getting transferred to a trusted geography, where the other side is also taking the same precautions and the same safeguards, that we would have taken, right? And then we said that if there is a particular sector, that sector requires data localization. For example, even today, Reserve Bank of India requires that the payment data should be localized fully. So we maintain that structure, which is a very flexible structure, and we have, to prevent any sudden disruption by any particular sectoral regulator, we have created a committee mechanism so that there is a proper consultation before any sector wants to impose a set of restrictions.
So essentially there is that window for the regulatory mechanism of a specific sector to prescribe what forms of data are to be localized. You use the RBI example.
That is there in this rule, in the Act, Section 16 already in the Act, and I think that's a very pragmatic way of looking at things rather than fully having a kind of one brush paints all kind of thing. It's a very pragmatic way of looking.
Just a couple more questions, sir. At the very outset, you began by telling us how this is a completely digital framework. The Data Protection Board, I think one interesting bit that falls was, of course, like I was pointing out, that this will operate entirely virtually. Chairman members will conduct meetings virtually. Just give us a sense, what does this translate into in terms of functioning of the DPB? How will it work? And where can the orders of the DPB be appealed? Is there an appellate tribunal framework?
That's a very clear framework prescribed of multiple levels so that the citizens' rights can be implemented without going through a very cumbersome legal process, right? So it will be a totally new way of working. We have had examples of digital implementation, various things in the last 10 years. Honorable Prime Minister has implemented Digital India as a part of every sector, right? So learning from all that has been implemented so far, this new digital by design, right from beginning, everything being digital, right from lodging a complaint to getting a hearing to making sure that the data fiduciaries give their response to the final order, then the appeal mechanism, everything is digital by design. And it's very well thought through. There is also a provision of voluntary undertaking, which means if somebody understands that it has caused a problem, it has violated the provisions of the law, that person, that firm, that company can go to the Data Protection Board and say that, okay, we made this mistake, so then it can be treated in a totally different way. So all those things are very well thought through.
One final question, sir. This one is with respect to government entities collecting data. I'll just ask a twofold question. Number one, as far as exemptions are concerned, exemptions are provided for the government services being provided, government subsidies, benefits, or licenses and permits being provided. Will that not cover a large chunk of the government functioning as a whole? Number one.
See, the government is also equally obligated to protect citizens' privacy.
Sure.
And most of the provisions of this Act, they are applicable to every data fiduciary, right? Regarding the, if a particular person has applied for one set of service, right? Isn't it proper that the person shouldn't be required to do the same set of submissions for another set of services, right? That's the ease of living,
Sure.
right? So that is the thought process when we say that if a government department wants to basically use the data which has been provided for one service and the citizen says that it's fine, I would like to access the other service also. So that's the thought process behind this.
Wonderful, sir. And what does this transition window look like? You said
About
there will
2
be
years.
generous time. There's a 2 year.
About 2 years, but most of the industry is already prepared for it.